My name is Stephen Balkam. I'm the founder and CEO of the Family Online Safety Institute here in Washington, D.C. Welcome to this, our latest in the FOSI Briefs the Hill series. We have participants, I believe, from nearly 20 countries joining us, so quite an international flavor to our discussions today. The mission of FOSI, for those of you who are new to us, is to make the online world safer for kids and their families. We do that through working on what we call the 3 Ps of policies, practices, and parenting. That is enlightened public policy, industry best practices, and something we call good digital parenting. And one of the most important roles of our organization, we believe, is to convene and bring together the smartest minds and the best practitioners from government, from industry, the nonprofit sector, academics, researchers, to collaborate and to innovate in this space. And so today we're going to turn our attention to an institution that in many ways has been rather absent from this scene, apart from the early days of the web and the overturning of the Communications Decency Act. And of course, I'm talking about the Supreme Court, an institution that holds immense power to shape not policy, but the way in which we conduct ourselves online. So last week, the Supreme Court heard 2 cases that have the potential to drastically change some of the apps and platforms that we use every day. In Gonzalez versus Google and Twitter versus Tamnay, the justices considered whether or not online platforms can be held liable for decisions made by algorithms and content recommendation systems. This question forces the court to grapple with the significant and often misunderstood statute that is credited with creating the internet, and that is Section 230. These 2 cases have the enormous potential to reshape free speech online, determine future best practices for content moderation, and maybe even inspire Congress to respond by updating, clarifying, or rejecting Section 230 altogether. So to help us navigate these difficult and choppy waters, I'm going to hand things over to my colleague and the FOSI policy manager, Andrew Zack, and to an outstanding panel of experts. Andrew?
Excellent. Thank you so much, Stephen. And welcome, everyone. As Stephen said, I'm Andrew Zack, policy manager here at FOSI. And before that, I worked on the Hill for Senator Markey. And I'm really excited about this conversation today and to bring in my fellow panelists. So I'll ask them all to come on screen and let each of them briefly introduce themselves, and then we'll get into the discussion and we'll go alphabetically. So Caitlin.
Hi, good morning, everyone. Thank you so much for coming this morning to talk about Section 230. My name is Caitlin Vogus. I'm the Deputy Director of the Free Expression Project at the Center for Democracy and Technology. We're a Washington, D.C. based nonprofit that work on tech policy issues, a lot having to do with free expression and online privacy. And we have done a lot of work on Section 230, including filing amicus briefs in the recent Supreme Court cases. So I'm very excited to talk with you today. Thanks.
Thanks for being here. Maybe Jennifer.
Hi, everyone, and thank you for joining us today. My name is Jennifer Huddleston, and I'm a Technology Policy Research Fellow at the CATO Institute. My research largely focuses on the intersection of law and technology, including issues related to antitrust, online speech, including Section 230, as well as data privacy.
Excellent. And Keith.
Hi, I'm Keith Chu. I'm a Chief Communications Advisor for Senator Wyden, who was a co-author of Section 230. I do a lot of work on free speech and internet policy for Senator Wyden, and in my previous career, I was a reporter. Thanks.
Excellent. Thank you all for being here. So I wanted to flag for the audience that we'll be taking their questions throughout this discussion. So please use the Q&A function at the bottom of your screen to submit questions, and we'll try to get to as many as possible. But first, I'd like to spend a minute defining some key terms that we'll be using today. What is Section 230? We have a fairly international audience today with people tuning in from Tunisia, Zimbabwe, Pakistan, India, and even some in the middle of the night in Singapore, New Zealand, and Australia. And while Section 230 affects how everyone around the world interacts with online platforms, it is still a uniquely American statute. So for the non-lawyers among us, what is Section 230 and how does it shape our everyday online experiences? Maybe we'll start with Caitlin and then maybe get some legislative history from Keith.
Sure, absolutely. So Section 230 is a federal law that shields online platforms for liability from most legal claims that are based on the things that their users say. So what does that mean in practice? Let me give you an example. If I am a Twitter user and I defame Andrew on Twitter, I say something defamatory about him, under Section 230, Andrew could sue me for defaming him, but he couldn't sue Twitter. Twitter would be shielded from liability for my defamatory speech. So at its heart, that's what Section 230 says. But it's important to know that Section 230 isn't without limits. So platforms can still be held liable, for example, violations of federal criminal law. And they can also be held liable if they co-create speech with their users or for their own speech that they post online. And then Section 230 also doesn't apply to claims that aren't based on third-party content. So for example, if there are claims about violations of data privacy laws or antitrust laws, those are not about third-party content. And so Section 230 wouldn't apply to them. And Section 230 has been enormously consequential for online free expression and also for encouraging platforms to voluntarily moderate content online. And the reason for that is, first, because of the liability shield, platforms are much more comfortable being in the business of hosting user-generated speech. They know that they won't be held liable for the speech of their users, and so they're more likely to engage in that business. And then they're also, when they do so, more likely to allow users to speak freely online. If you had the opposite situation where they had a lot of fear of liability, providers would tend to over-remove a lot of user speech, which I know is something we're going to talk about more in detail later in the panel today. And then when it comes to content moderation, and I know Keith can speak in more detail to this, Section 230 encourages platforms to voluntarily engage in content moderation, essentially because before the law was passed, courts had interpreted common law principles around liability to make it riskier for platforms who voluntarily moderated speech, to make it more likely that they could be held liable than platforms that didn't do anything at all. And so Section 230 changed those common law principles because Congress wanted to encourage platforms to voluntarily self-regulate and engage in content moderation on their services.
Thank you. Keith, if you want to elaborate or give any legislative history as well.
No, I think that was a great introduction to the law. The way Senator Wyden sometimes summarizes Section 230 is the person who creates content is responsible for it. So that Twitter example I think was really good. The other kind of framing that I think is helpful is it gives companies a sword and a shield. Effectively, it gives them a shield against being liable for things that their users post, but it also enables them to take down content that they don't want on the platform. It resolves the problem of, if you look for bad stuff and don't find everything, you're not liable for everything, for missing something online. So those are that was essentially trying to solve the moderator's dilemma back in the early days of the internet, as Caitlin described.
Thank you. That's great context. And so moving into the cases a little bit, what is Gonzalez v. Google about? What is Twitter v. Tamna about? What are the cases about? What are the key questions in each case, since they are a little different? Maybe Jennifer can bring in this, or Caitlin.
So to start with, the Gonzalez v. Google case is the case that has largely received probably the most attention, both in the press as well as when it comes to the discussion of the impact of Section 230. At the heart of this case is really a question about whether algorithms themselves are protected by Section 230, or whether those should in some way be considered the platform's own speech or otherwise not fall under this particular purview. There are some very sad facts at the heart of this case, and I think one must certainly acknowledge that the underlying circumstances are not something that's very enjoyable to think about, and are certainly very sad. But we also have to take a step back and look at the legal question and look at how algorithms have been used online and what the potential consequences of the court ruling in this case would be, as well as look back to the text, look back at what are the tests laid out in the original text of Section 230 to help determine whether or not it should apply in this particular case.
Yeah, and I would just add to that, Jennifer alluded to the sad facts, and they are indeed very tragic. And just to make it a little more concrete for the audience, in case they're not familiar with the cases, the plaintiffs in the cases are the family members or estates of people who were killed in terrorist attacks. And they've brought lawsuits against online services. So in the Gonzalez case, it's YouTube, and in the Tomna case, it's Twitter. Alleging that those services should be liable under a law in the United States called the Anti-Terrorism Act, because essentially what they say is that they recommended content from ISIS to users. So in the case of YouTube, they say that users who had previously viewed ISIS content or were interested in it were recommended more ISIS content, and in Twitter, similar facts of recommending posts. And also failing to take down every single instance of content posted by a terrorist group, leading to potential liability for aiding and abetting those groups. And I think that, of course, those are very powerful claims, and we have real reasons to be concerned about terrorist content online. But as Jennifer was saying, it's important to look at the law itself and to also think about how the potential outcome and interpretation of Section 230 could have impacts on wide swaths of user-generated speech that have nothing to do with terrorist content at all. And so in Gonzalez, with the issue being, when should platforms be liable for recommending user speech? Is that something Section 230 shields or not? Depending on how the court interprets 230, that could have really broad ramifications, because one thing we know is that so many different services online use some form of recommendation or another. And that could be everything from a very complicated algorithmic form of recommendation that's highly targeted, but it could also be just much less sophisticated measures. For example, if you have a homepage and a provider makes choices every day of what content to put on the homepage, what third-party content to feature there, could even be hand-selected, not algorithmically. Is that a recommendation as well? And so when you start to pull at the thread of the plaintiff's claims in these cases, you see very quickly how it could have a lot of ramifications beyond just the specific facts of those cases.
Excellent, thank you. So I want to get into the consequences and the impact of these cases, but first I want to follow up on something that you both touched on in terms of the original intent of the law, or why it was written to exist. And so I think these cases are different than many cases in the Supreme Court for many reasons, but especially with this one, a lot of the Supreme Court focuses on the question of original intent. What did Congress really mean when they passed a law? What were they thinking about? What were their goals? But Section 230 cases, as we've already said, are different, since both authors are very much alive and part of the discussion. So I was hoping to briefly talk about how both Senator Wyden and Representative Cox have weighed in on this, and how their law might reshape the court's thinking.
Yeah, I'll jump in there. Yes, Senator Wyden and Congressman Cox have been pretty vocal, right, about their intentions with Section 230. So sometimes it's frustrating to hear folks mischaracterize the intent of Congress when they were drafting this law. They filed a brief on Gonzalez v. Google. Since this is the first Section 230 case the court has taken, despite declining to do so for many years. Justice Thomas and Justice Alito clearly have been pretty vocal themselves about their desire to change Section 230 and actually force companies to carry more content, which at least my boss would see as harmful and things that we would not want online. So Congressman Cox and Senator Wyden thought the court should hear directly from them, the co-authors of the law. They focused in their brief, and I think the point that they would want to make publicly as well is that Section 230 does not just protect big social media companies, which kind of gets the most attention in the news. Senator Wyden's goal really is to protect users so that they're able to speak online and have access to interesting content. And then second, the startups and the smaller companies that can compete with the big companies and in some ways incentivize them to have better platforms, to have less of this objectionable content online. And so the point that they make in their brief is that the justices should be very careful about changing Section 230 from the bench, especially in ways that would upend the online ecosystem, leave users and smaller companies worse off, and let big companies like Facebook and Google grab even more share of the online marketplace, which I think most people would say is not what they want.
Thank you. Yeah, it's always good when you can hear from the people who wrote the law. And so we've had a full week since both these cases were heard. So a little bit of time to digest what happened. And I know we've posted links to both the transcript and the audio recordings. But for anyone who hasn't listened to those 5 hours of arguments or read the hundreds of pages of transcripts, could we briefly talk about how the justices reacted and what important questions did they ask and how did they seem to respond to each side's arguments?
I think the justices were very well aware of the significance of this case. I think you saw them asking a lot of questions about what accepting this argument that algorithms were not protected would mean for the internet and would mean for things beyond just social media platforms as we traditionally think of them. Because as was mentioned previously in this conversation, you certainly see that Section 230 applies to a much wider range of platforms than it often gets portrayed, that this isn't just about the Googles and the Twitters who may be the plaintiffs in this case, that this would have a much broader impact. I think you also saw a great deal of intellectual humility from some of the justices, acknowledging that they were, quote, not the 9 greatest tech experts on the planet. And so you saw an awareness that there were technical elements that were at play that would need to be understood in order to consider how things might play out. I also think you saw some kind of discussion around speech issues online that, while relevant to these cases, also are going to be relevant to the kind of ongoing content moderation debates, including cases that the court may take up in the near future involving laws that would regulate online content that stem from Texas and Florida laws that are currently under challenge, and that there's a bit of a circuit split on the decisions there. And then you saw some very interesting novel questions. Justice Gorsuch, for example, brought up the question of kind of generative AI and how that would interact with Section 230. So you certainly saw that they were really attempting to grapple with the full challenge, both of the implications of potential changes as well as their own limitations as a court.
Yeah, I agree with Jennifer. The justices asked very thoughtful questions and were clearly aware of the stakes of the case and the broad ramifications of their decision. I guess one thing I wished the justices had asked a little bit more about, or more explicitly about, is this issue of what would be the impact on regular everyday users from their decision. They asked many questions about how their decision could change kind of the business model of the internet and how it could impact tech companies from a business perspective. But I just wanted them to draw that line, that just one further step that goes to then also to user speech. And what do I mean by that? The reason I talk about that is because if you think about if platforms were liable for content, third-party content by their users that they recommend, how might they react to that risk of liability? And I think one of the big ways that they would react to that risk of liability is by taking down a lot of user speech that is totally constitutionally protected and is even really beneficial, things that we want to have online. So even if we're just staying in the realm of, for example, content related to terrorism or radicalization, of course, no one wants to see content from ISIS being posted freely online. But there's also other content like news reports about terrorist attacks, like human rights documentation when it comes to terrorist attacks, anti-indoctrination materials, statements condemning terrorism, all sorts of speech that is constitutionally protected, it's good, we want it out there, but platforms would have a very hard time distinguishing that from the bad types of content that could expose them to liability. And so they would react by just taking all of that speech down. And that could have really harmful effects on everyday internet users and our ability to speak, and also on our ability to receive information online, to find out what's happening in the world. And I just wanted the court to really focus in on that, because I do think that's at the heart of the impact of its decision. And I hope when it goes back to chambers and is deliberating, it's reading many of the amicus briefs that were filed on this point, it's thinking about this, and it's really bringing it back to everyday people, because that's ultimately, I think, what should be driving the court's decision in these cases.
Excellent. Thank you. No, there are a couple different threads that we'll follow up on, but yeah, I think it is definitely refreshing that the justices seem to be understanding the seriousness and how influential these rulings could be. I want to follow up briefly when Jennifer mentioned this to bring in some other cases, such as Texas and Florida content moderation / censorship laws that are likely to reach the Supreme Court during the next term. I'm sure many of you are familiar, but as a very brief summary, Florida passed a law last year that basically prevents online platforms from banning or downranking the accounts and posts of politicians or anyone running for elected office in the state. And Texas passed a similar law that bans platforms from moderating content based on viewpoint under the premise of fighting censorship. So both states have been sued, and the appeals are working their way up to the Supreme Court. But for full transparency, FOSI did sign on to an amicus brief related to the Texas law, and I believe CDT has also worked in amicus briefs here as well. And so I guess what I want to ask about these are, how are these pending Texas and Florida cases related to Gonzalez and Tamna, and how could these current cases maybe lay the groundwork for future speech-related cases and lawsuits?
I can take this one. I think it's very interesting that these cases are all kind of percolating up to the court around the same time. The court hasn't granted cert yet in the Texas and Florida cases, but they're pending before the court on cert petitions. And in a lot of ways, the Texas and Florida cases are very much in tension with the Gonzalez and Tamna cases, because in Gonzalez and Tamna, the issue is about the platform's alleged failure to take content down, that they left too much terrorist content up on their services. Whereas in contrast, the Florida and Texas social media laws are saying platforms must leave content up. They must continue to carry content and are written in ways that could really hamstring platforms when it comes to their ability to engage in content moderation, to do things like remove hate speech and disinformation and all sorts of content. There are some limited exceptions in the Florida and Texas laws that allow some removals, but to a large extent, they're kind of must carry laws. You must carry this content. So it will be very interesting to see if the court is thinking ahead to the net choice cases when it's making the decision in the Gonzalez and Tamna cases, and contemplating that tension around, do we want a regime that is coming down hard on platforms for leaving too much up, or are we going to accept this regime that is telling them they have to carry content? And I just think we could really see some fundamental shifts in the legal liability regime governing the internet coming out of the court in the next year to 18 months to 2 years, and it could really reshape the online speech environment for everybody.
I think it's also, though, important to distinguish kind of the position of these two cases as well. Andrew alluded to this by mentioning that these really are censorship laws, in that they're allowing the government to dictate, what type of material has to be left up or taken down when it comes to the law, the challenges to the laws in Texas and Florida. And so the net choice and CCIA cases against those laws are really First Amendment cases. Gonzalez and Twitter v. Tamna are really focusing on Section 230 specifically. But when we're talking about online speech, we oftentimes need to separate the concerns between the First Amendment and the platform's First Amendment rights, users' First Amendment rights, and the government's actions, as well as what specifically does Section 230 say, to really determine what the issue at hand is. Because oftentimes, particularly when people are frustrated about either what online content has been left up or what online content has been taken down, they rush to kind of call on Section 230 when really the underlying issue may be more of a First Amendment issue.
That's a great distinction between First Amendment and Section 230. Thank you. I know those can often be conflated and are also both pretty uniquely American. So it's good to differentiate there a little bit. I'm going to bring in an audience question in just a second, but wanted to quickly follow up on the states side about how states can even regulate content moderation, or if it might need to be done at the national or international level to ensure consistent enforcement and prevent maybe even further marginalizing certain groups of people. Curious if folks wanted to weigh in on that.
I could jump in briefly. One of the goals of Section 230 clearly was to create a federal law to govern content moderation so that you didn't have 50 separate state laws, essentially chopping the internet into a bunch of tiny pieces and making it harder to communicate. And I think that the laws that we are seeing in Florida and in Texas are a really good example of why that's important, even though I certainly agree that those are at core First Amendment issues, not Section 230 issues. But the fact that you have certain politicians who are really pushing hard to censor voices that they disagree with politically, racial justice movements, LGBTQ voices, among other things, abortion-related content, not just for children, but for everyone, I think gives a very good argument for why we don't want the government to control all internet speech, and at least to be very cautious about how we do that, so that we are narrowly targeting things that are really harmful and not just areas of political disagreement.
I think one of the things about looking at this on a national level as opposed to a state level is that it helps overcome a patchwork problem that could have been very difficult, not only for emerging companies, for companies of all sizes, but also for users. That when it comes to the kind of questions of online speech, if you have a different kind of set of rules in Maryland versus Virginia, I'm thinking about this for many of us that are located in the DC area where states are very close together, it may be confusing both for an individual platform to know what they have to leave up and have to take down, because you may end up with conflicts in those laws when it comes to certain content, as well as for an individual user to have their voice heard on a wider scale, not just, and one of the great things about the internet has been how it's allowed us to connect with people much farther away and to really gain new perspectives and new information beyond our kind of own local community.
Thank you. I know, yeah, we could expand and talk about all the privacy laws or other state-by-state regulations that are happening, but don't want to get too beyond the scope of this framing. And so I'm actually going to bring in a audience question first that goes back to sort of potential outcomes of this case. So they write, should SCOTUS rule that recommendation of third-party content via algorithms is not protected by Section 230, removing the immunity protection? How may that impact non-social media platforms, such as websites that allow for user-generated content that is ancillary to their service, maybe like comments on a news site? Have any of the amicus briefs made distinction or talked about these potential consequences?
I think it could absolutely affect companies who allow user-generated content, but just as an ancillary part of their business, because they are shielded by Section 232 as it's currently interpreted. So for the comments on a news site is a great example. The newspaper or news outlet is not responsible legally for the comments posted by their users in the comment section on the news website because of Section 230. And certainly some of those services do use prioritization of their comment section. I definitely myself have been on news websites, and you go to the comment section and certain comments are highlighted or promoted as being the most interesting or providing a different perspective or something like that. And so they could definitely be impacted by a ruling that all of a sudden would mean that they could be held liable for content like that. And one way that companies might respond, especially if hosting user-generated content is just an incidental part of their business, is to decide, I don't want to host user-generated content anymore, and to take that part of their business away. And that makes sense for them as a business decision and a legal risk decision. But what it means for all of us as users is that we have less ability to speak online, and all of a sudden we can't share our thoughts on that news article and make our voices heard. So I think it could have impacts on a lot of different types of services, and then on the users of those services too.
I would like to add that in addition to kind of ancillary services, that there are a lot of different types of user-generated content out there beyond just social media that many of us use and find incredibly useful. Review sites is one that often comes to mind. You know, since the growth of the internet, we no longer only have to go to what the expert in the local paper thinks about the new restaurant that opened. We can very quickly have a whole range of opinions. You know, when parents are looking to find out about new toys that are on the market or to find the best baby stroller, they're able to get advice from people in similar situations and what they thought of the product, as opposed to only having kind of the certified expert advice. Another great example of this is Wikipedia, which many of us find very useful for learning about new topics and can be updated much more quickly than the old Encyclopedia Britannicas could be, but it relies on users and on user-generated content in order to do that. So when we're talking about Section 230 and when we're talking about user-generated content, we often also have to consider many other types of internet services that we're using.
Yeah, thank you for especially bringing in review sites. I think that's something where, you know, if anyone, the platform could be held accountable for any negative speech. I think there'd be, you know, so many lawsuits of a bad restaurant review type of thing. Oh, this person is trying to slander me or my restaurant. I want to shift this a little bit towards, so earlier this week, we met with FTC Commissioner Alvaro Bedoya, and he reiterated how one of his top priorities relating to online safety is the teenage mental health crisis and technology's role in it. He also said something that I found particularly interesting, that he was potentially less interested in focusing on algorithmically recommended content, and that platforms and products designed to maximize engagement could be the more significant cause of harm. So not necessarily the harmful content that is recommended to users, but the engaging algorithmic recommendation system itself could be the most harmful. And maybe legislation, regulation, and lawsuits could focus on the design aspects. I mean, this makes sense from his perspective, considering a core directive from the FTC is to focus on unfair or deceptive trade practices. But I still thought it was important to note that regulators are watching these cases in the court and state legislatures very closely. And where I'm going with this is to bring up some other recent lawsuits, including a large one in California that is focused on harmful or defective product design, and also the Seattle School District's lawsuit focusing on youth mental health. And we don't have to get into the specifics of everything, but curious how decisions in Gonzalez or Temna impact these and other future lawsuits, focusing maybe more on product design. Is that different enough from harmful content that it wouldn't be thrown out of court based on Section 230 grounds?
So as you mentioned, Andrew, you know, many of these issues are being actively litigated in lower courts right now. And we've had some decisions going one way or another on whether kind of product design issues are shielded by 230 or not. Of course, one of the issues we see with online speech cases is that sometimes plaintiffs can try to use creative pleadings to get around 230 to make it sound like they're not talking about user speech, they're talking about something else. I'm not saying necessarily that's the case in product liability cases, but that's one thing courts are thinking about when they're talking about these cases. It's definitely something that came up in the briefing in the Gonzalez and Tomna cases. And so I'm sure the court is thinking about it. I guess I would hope that the court doesn't take the opportunity in Gonzalez and Tomna to weigh in on this, because those cases don't present a products liability fact pattern. That's not the claim the plaintiff has made here. And in our legal system, it's very important. We think that courts kind of limit themselves to the claims that's before them, so the facts can be developed, so the law can be developed. And because these issues are being actively litigated in courts below, we're kind of seeing the development of the law here. So I wouldn't be at all surprised if the Supreme Court in the future takes up a products liability, products design case. But I hope that it doesn't kind of in dicta or something, say something about that in Gonzalez and Tomna, because it really doesn't need to resolve those cases. And I just would be worried about the chaos that could be created if it decides to say something one way or another.
Yeah, and I'm not a lawyer, so I won't weigh in on those cases. But I guess one thing I would want to point out, which is also in Senator Wyden's brief, is that the courts have, certainly ruled that when you're talking about product design, in some cases like the Snap speed filter, case where that's a function of the software, it has nothing to do with user-generated content that was created by the company. That's not protected by Section 230. Or a couple other cases where Amazon delivers defective products or websites provide illegal online home rentals, also not protected by Section 230. We're talking about things that the company does, not user content. And so I think the jurisprudence to some degree is developing there and drawing those lines as we go. But yes, agree. It's very dependent on the facts, and it's very difficult to figure all of that out right now.
And Andrew, if you don't mind, I want to take this question a little bit of a different way and go back to something Caitlin said earlier about the impact of changes if to Section 230 on the everyday user. Oftentimes when we are thinking about algorithms, we're thinking about those kind of constant recommendations of what to watch next or things like that. But algorithms are also very useful in content moderation. And we've seen this laid out, particularly in some of the briefs that were filed. And so for people who are concerned about the content that young people may be exposed to online, algorithms can play a key role in helping content moderation occur to remove harmful content as well. And so we also have to consider what would happen if there's no longer a protection that makes companies feel that they can use algorithms in content moderation decisions for those helpful uses of algorithms, especially.
That's a great point, bringing in some of the sort of unintended consequences that could limit online safety. Wanted to follow up on this as well, since there's a particularly interesting, I'm thinking of a particularly interesting amicus brief from Reddit about sort of like, I know, Jennifer, you can expand on this. So sort of like how online safety might be impacted from these cases that many people haven't thought of, or at least it's not getting the most attention.
So I think the Reddit brief is one that's certainly interesting to highlight, and that I find personally to be very impactful when it comes to the point of how moderators are able to use these tools to engage in content moderation. And the Reddit brief was filed on behalf of subreddit moderators who are volunteers. It has a different kind of model of content moderation, a much more decentralized model of content moderation than some other online platforms. And they were talking about how having the access to these tools makes it possible for them to do these jobs as volunteers. And also they're concerned that if they weren't able to use these tools, or if there was a change to Section 230 that would remove the protection from the use of these tools, that they would be personally liable, and how that would discourage them from engaging in this important task of content moderation for these subreddits. And when you're thinking about these subreddits that are often focused on, very specific interests or a certain group and a certain community, they're able to form the rules that serve those communities in ways that may differ from one another. And so really thinking about how this can impact the options available to engage in that good faith content moderation as well.
Excellent. Thank you. Thank you for expanding on that. And so I know we're talking a little bit about sort of the platform, the good that content moderation can do through platforms can do content moderation through these algorithmic recommendations, but also thinking about community moderators and that sort of thing. Is there more on the individual side as well, like user control side, potentially at risk? Whether that's, FOSI's done some research over the past couple of years about parental controls or online safety tools for all users, but especially young users, where they can customize their settings. Would that almost be at risk in some of these interpretations or rulings? And I know that's something that platforms have really, spent a lot of time building out, trying to make them useful in hopes of making their online experiences safer.
I think that's a really interesting question, Andrew. I don't know. I can't speak authoritatively to all the different types of parental control tools and everything like that. But one thing it brings to mind for me is just the potential unintended consequences of a court decision that does say that recommendations are outside of 230, because what 230 has allowed for is great experimentation amongst platforms in doing things like offering different tools to users to allow them to control their experiences. And because the term recommendation is so vague and could be defined in many different ways, I could see services being extremely wary of offering those types of tools, of experimenting in new directions in what they're going to allow their users to do to better control their experiences, because they're going to be afraid that some plaintiff will come along and say, oh, that's a form of recommendation, and the court has held that's outside of 230, if that's what the court were to hold in Gonzalez. And so I do worry that there would be a lot of disincentive to develop things like that, to continue with tools that are already in existence if the court does hold that recommendations are outside 230.
Thank you. We've received, I want to bring another question from the audience. We have received a question from a parent who has lost a child to a dangerous challenge that their son saw online and tried to replicate it before going horribly wrong. And so first of all, I want to offer them my personal condolences and truly thank them for getting involved and remaining engaged in these online safety discussions, which are surely triggering for them, yet they want to be part of the conversation to prevent more families from going through what they've gone through. So their question is, can Section 230 be reformed to state that when platforms use algorithms and choose to share harmful content by sponsoring the content or being paid to share the content, they are therefore contributing to the harms and should be susceptible to litigation? Or to put it a slightly different way, when can companies be sued for what users experience on their apps and platforms? And should any existing liabilities be expanded to include algorithms amplifying harmful content? And I know Caitlin had already touched on some of this in her opening answers about the limits of Section 230, but if we can address this question, it'd be great. Thank you.
Yeah, Caitlin mentioned some of the existing carve-outs to Section 230 around issues like federal criminal law. We saw a few years ago the passage of FOSTA SESTA, which creates additional carve-outs and liability for content related to sex trafficking. Issues as it relates to intellectual property are handled under a different regime, the DCMA or DMCA, excuse me. When we're looking at whether or not Section 230 applies, if you go to the text of the statute, there really are three parts to it. The first is the question of, is this an interactive computer service? When we're looking at the cases before the court now, I think it's pretty straightforward that both Google and Twitter are interactive computer services. The next question is, does the claim against it treat it as a publisher or a speaker of the content? And that goes back to how Section 230 was constructed. And then the final element would be, is the content provided by another information content provider? Are we looking at those questions of, is the platform itself the speaker? Did they create the content, or is this content that was created by another provider? As Keith and Caitlin alluded to earlier, there are some questions around product liability that have come up around issues like the Snapchat speed filter that are currently working their way through the lower courts. There have also been questions where platforms were found not to meet one of those elements. For example, in the roommates.com case that had to do with specifics of discrimination and the way that the drop-down menus were constructed on that particular website. So I say all that to say that grounding this in the text of the law is what I think is very important when we're considering Section 230. And then when we're considering broader conversations around online speech, we do also have to consider the First Amendment. And I should have started my answer with this, but to follow up with what Andrew said, you know, it's horrible that for this mother to have to go through that, and I am certainly sorry for her personal loss.
I would just add, I think Jennifer did an excellent job of describing how Section 230 works and the various elements. And you know, this is a very difficult and nuanced issue, and it is reasonable to want to have a conversation about when should platforms be liable for some kind of specific act that they themselves are responsible for that results in a harm. And can we change Section 230 to get at those situations? One way that this has come up frequently and came up, in fact, in the Supreme Court arguments last week is around the discriminatory targeting of advertisements. So in the arguments last week, the justices asked both sides hypotheticals around a dating app. What if there was a dating app that was targeting profiles in a discriminatory way? You know, white people only to white people, Black people only to Black people. Should platforms be liable then? And there's a real case involving Facebook and housing ads, where Facebook settled a case with the government where it was accused of discriminatory targeting ads for housing based on race and other protected characteristics, excuse me. And so there is a real interest in trying to see, you know, does Section 230 already carve this out? If not, is there a way to amend Section 230 to get at this situation where it really doesn't have anything to do with the content of the that's been posted? It's really solely down to something the platform has done. So in the housing example, it's not that the person who posted the ad said whites only in their housing ad. You know, the ad just says room for rent, and the person posting the ad doesn't try to target it in a discriminatory way. It's the platform itself, perhaps, that is doing the discriminatory targeting. And should there be some sort of narrow carve out to 230 in that instance that would allow the platform to be held liable? So I think that's certainly, again, something that the court is going to be interested in examining more closely based on their questions in the oral argument. It's not something that's raised directly by the Gonzalez or Tomna cases, but I could see a future case on that. And I know it's something that Congress is looking at very closely too. And many civil society organizations like CDT as well. So these conversations are important. We also have to keep in mind unintended consequences and if there could be impacts on user speech, and take that very seriously when we're thinking about these sorts of changes. But they're definitely part of the conversation, and it's where I expect a lot of the work on 230 to go in the coming months and years.
So you transitioned for me perfectly. I was going to call this the what to do about it section and bring in Congress a little bit, since it seems like we've already alluded to Justice Kagan, but she suggested that perhaps Congress is the best body to amend 230 and would maybe prefer lawmakers to take a scalpel to the law to avoid lots of lawsuits in the court's reinterpretation of the statute that would upend years of legal precedent, according to Kagan. And so I'm curious what you all think Congress can do to amend, update, or clarify Section 230 and what you might recommend they do.
So maybe I could, two parts to my answer. The first would be that I think that, you know, certainly Senator Wyden is open to changing Section 230 if there are changes that, solve real problems and create minimal collateral damage to speech and to free expression online. That's something that he's said for a while, and is constantly evaluating proposals to make sure that they don't target constitutionally protected speech and don't discourage moderation. Those are his sort of two tests for change to Section 230. Unfortunately, most of the bills on offer so far it would either target constitutionally protected speech or make it harder to moderate bad content. The other point I would make, though, which is relevant to a couple of the other questions, is that there are ways to disincentivize some of these platforms from hosting bad content, and from this sort of engagement model that is at the root of a lot of, I think, bad behavior by companies. And in Senator Wyden's mind, going after privacy and creating stronger privacy protections is really the first step that Congress could take. Right now, it's profitable for companies to ignore bad behavior because they can harvest a lot of personal information without any limits, any real limits on how they use or share that data. And so, something Senator Wyden and I think a lot of advocacy groups have been pushing for is a strong federal privacy law that goes to the heart of the business models and would stop them from targeting harmful ads in such a sort of pervasive way. When people talk about the addictive nature of social media, including, especially for kids and teenagers, we think this is one way to make it not profitable for companies to do that without creating some troubling First Amendment problems that some of these proposals are talking about.
I think that was really well said. I agree with Keith, and CDT has been a big proponent of comprehensive federal privacy legislation, as well as being a way to get at many of these issues that does not ultimately, in a manner that doesn't ultimately affect user speech, which we think is important. In terms of changing 230, there's no specific proposal that I would make. I would just say that if Congress is looking at that, doing that, what I think they need to do is focus on a very specific issue where the role of the intermediary in causing the harm they're trying to address is very clear. The interest of the government in addressing that type of harm is well articulated, and the law is narrowly tailored, and also really considering the impact on user speech. I keep coming back to that because that's just so important. And even laws that seem well-intentioned, that seem narrow, can have really disastrous impacts. And one example of that from recent years is FOSTA-SESTA, this law that was mentioned earlier, that created a carve-out to Section 230 aimed at sex trafficking content online. But unfortunately, what we have seen and heard from people is that it has actually made, for example, sex workers less safe, because it's led to sites shutting down health information, HIV prevention information, information sharing safety tips. It's impacted regular people, families, and teens as well by making it risky to host information about sexual health and education. And so even a law that was sold as being narrow ended up having these broad effects. And I think we need to keep that in mind as we're looking at any potential future changes to Section 230.
To build on what Keith and Caitlin have said, I think there are a lot of concerns about the potential First Amendment implications in many of the proposals or in all of the proposals that we've seen put forth so far when it comes to changing Section 230, both in terms of what it does to online speech, but also with the insertion of a government role in the case of many of the proposals. And we kind of mentioned the Florida and Texas laws before, but this is an example of the kind of concerns that arise with many of the proposed changes to Section 230. When it comes to kind of the carve-out approach that we've seen with FOSTA-SESTA when it related to sex trafficking, I think Caitlin excellently explained many of the unintended consequences of that. But there's a further complication if you start to see additional kind of specific carve-outs and little carve-outs along the way, in that it becomes much more unclear what the standards are, both for users and for companies that are trying to be in compliance. So if you kind of have this death by 1,000 cuts approach, you may still have a lot of the underlying issues of the moderator's dilemma that Section 230 was designed to prevent, and you may have growing compliance costs for companies that now don't have that kind of uniform rule, or rather uniform rule that they had initially under Section 230.
I think that's a good point. I also just wanted to build on what Caitlin was saying about Sesta Fosta. Totally agree with all of the points about the chilling effect that that's had. But also, I think it's been lost that law didn't solve any of the problems that it was supposed to solve, right? There's no evidence that that stopped sex trafficking. It hasn't even stopped advertisements for sex trafficking, which have largely moved overseas. And at the same time, it's led to, by all appearances, a big increase in violence, which is, I mean, just really terrible consequences all around. And so, that's just another thing that I think we need to be very careful about ensuring that things that sound good would actually solve the problems that they're talking about.
Yeah, thank you for bringing in Sesta Fosta. That was something that I hope we get to at least a little bit. So thank you. I want to bring in another audience question. It'll probably be the last one. Of Ann Collier wrote in: is safety by design the only thing in the spectrum of user protection that can address unintended consequences? Again, maybe shifting from sort of this is bad speech, this is content that was promoted, to fully designing products with safety in mind from the beginning. Recognizing that none of us are actively working for big tech companies or any tech companies at the moment.
I think companies should certainly be doing risk assessments of their products and trying to think through the potential safety risks for teens, for children, for everyone in their products. And that's something we're seeing Europe bringing in with the Digital Services Act. If we're talking about legislation involving safety by design or some sort of duty of care, I start to get a little bit nervous about what does that exactly mean? And more importantly, how could it be enforced? And it's been mentioned earlier, bringing government into these conversations. If we are in a world where we know that some politicians are really worried about LGBTQ content, content about the history of racism in this country, other types of content that they might say is not safe, but other people would disagree and say is critically important for us to be able to talk about online. I do think there could still be implications for user speech. And so I just think we have to keep that in mind and be careful of it.
Thank you. And I know it's crazy. We've already been talking for an hour, so we do have to wrap up. But my final question for each panelist is, in 30 seconds or less, what is one main thing that you want the audience to take away from our conversation today? I know it was a wide-ranging conversation, so the choice is yours for how you choose it.
I'll go first. I'll take that privilege.
Thank you.
I think the largest takeaway from this discussion and from these court cases is that the cases between the Supreme Court are about much more than just the two companies involved, that the impact of these cases goes beyond Google and Twitter, and also not only goes beyond Google and Twitter, but really goes to the impact on all internet users, whether they are young people or adults. And therefore, it's important to certainly pay attention to what comes out of the court, as well as what comes out of the ongoing conversations in Congress.
Thank you.
Absolutely agree. Just user speech has to be at the heart of all of our conversations around the intermediary liability regime in this country.
Yeah, the Congress certainly does need to do more to make the internet safer for kids and in general. But poorly thought out changes to Section 230 are really the worst way to deal with online safety issues, which is why Senator Wyden wants to start with privacy and look at some other ways to address harms that don't implicate user speech in ways that would be, I think, more harmful than helpful.
Well, thank you. Thank you, each of you. And unfortunately, we are out of time. So thank you to our fantastic panelists, Keith Chu, Jennifer Huddleston, and Caitlin Vogus for such a great discussion. And thank you to all of the FOSI staff who helped put this event together, as well as to you, the audience, for tuning in and submitting thoughtful questions. And I'm sorry that we couldn't get to more. For anyone who joined late or has colleagues who may be interested, a recording of this discussion will be on FOSI's YouTube page shortly. And to check back in on fosi.org/events regularly as we host these and other online safety events throughout the year. Thank you all again, and have a great rest of the day.